Good day, sir. My name is Cante Verano, and today I will be reciting Rule 130, Section 10 to 35. I will start at Section 10, the Parole Evidence Rule, Section 10, Evidence of Written Agreements. When the terms of an agreement have been reduced to writing, it is considered as all terms agreed upon there can be between the parties and their successor interests. No evidence of such terms other than the contents of a written agreement. However, a party may present evidence to modify, explain, or add to the terms of a written agreement if he or she puts in issue in a verified pleading. Letter A. Intrinsic ambiguity, mistake, or imperfection of a written agreement. Letter B. The failure of the written agreement to express the true intent and agreement of the parties thereto. Letter C. Validity of a written agreement, or D. The existence of other terms agreed to by the parties of their successors' interests and after the execution of a written agreement. The term agreement includes wills. Section 11, Interpretation of Documents. Section 11, Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning, its bearer and the place of execution, unless the parties intended otherwise. Section 12, Instrument construed as to give effect to all provisions. In the construction of an instrument, where there are similar provisions or particulars, such a construction, if it's possible, to be adopted as will give effect to all. Section 13, Interpretation according to intention. General and particular provision. In the construction of an instrument, the intention of parties is to be pursued when general and particular provision are inconsistent. The latter is paramount to the former. So a particular intent will control a general one. It is consistent with it. Section 14, Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject, thereof, and of parties, it may be shown so that the judge may be placed into the position of those language he or she is to interpret. Section 15, Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. And we have the Section 16, Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former controls the latter. Section 17, Experts and interprets to be used in explaining the certain writings. When the characters in which an instrument is written are difficult to be deciphered, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the characters or the meaning of the language. Section 18 is of two construction which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he or she supposed the other understood it. And when the different construction of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Section 19, Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against in the former, is to be adopted. Section 20, Interpretation according to usage. An instrument may be construed according to usage in order to determining its true character. The testimonial evidence. Qualification of witness. Section 21. Witnesses, their qualification. All person who can perceive and perceiving can make known their perception to others may be witnesses. Religious or political belief, interest in the outcome of the case, or conviction of the crime unless otherwise provided by law shall not be ground for disqualification. Section 21. Disqualification by reason of mental incapacity or immaturity. Section 22. Testimony confined to personal knowledge. A witness can testify on those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her perception. Section 23. Disqualification by reason of marriage. During the marriage, the husband or wife cannot testify against the other without the consent of the affected spouse, except in a civil case by one against other, or in a criminal case or for a crime committed by one against of the other and latter's direct descendants or ascendants. Section 24. Disqualification by privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. A husband and wife during or after marriage cannot be examined without the consent of the other as to any communication received in confidence by one from the other during marriage, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. B. An attorney or person reasonably believed by the client to be licensed to engage in a practice of law cannot, without the consent of the clients, be examined as to any communication made by the client to him or her, or his or her advice given thereon in the course of or a view of a personal employment, nor can an attorney's secretary, stenographer, or clerk or other persons assisting the attorney be examined without the consent of the client and his or her employer concerning any facts of knowledge which has been acquired in such capacity in the following cases. Paragraph 1. Furtherance of crime or fraud. The service or advice the lawyer sought to be obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should be have to be a crime or fraud. Number 2. Claimants through the same deceased client. As to communication relevant to an issue between parties who claim through the same deceased client, regardless or whether the claims are by testate or any intestate or by inter vivos transaction. Number 3 is breach of duty by lawyer or client. As to communication relevant to an issue of breach of duty by the lawyer or his or client, or by the client, his or her lawyer. Number 4 is document attested by lawyer as to a communication relevant to an issue concerning an assisted document to which lawyer in assisting witness, or number 5, joint clients as to a communication relevant to a matter or cannot interest between two or more clients if a communicate was made by any of them to a lawyer retained or consulted in common when offered in an action between any of the clients, unless they have expressly agreed otherwise. C. A physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the parties' physical, mental, or emotional condition, including alcohol, drug addiction, between the patient or his or physician or psychotherapist. This privilege also applies the persons including members of the patient's family who have participated in the diagnosis or treatment of the patients under direction of the physician or psychotherapist. A psychotherapist is a person licensed to practice medicine engaged in the diagnosis or treatment of a mental or emotional condition, or B. A person licensed as a psychologist by a government while similarly engaged. D. Or a minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made to or any advice given him or her in his or her professional character in the course of discipline enjoined by the church to which the minister or priest belongs. He is public officer cannot be examined during or after his or her tenure as to communication made to him or her in official confidence when the court finds the public interest will suffer by the disclosure. The communication shall remain privileged even if the hands of a third person who may obtain the information provided that the original parties to the communication took reasonably precaution to protect its confidentiality. Number 2 is testimonial privilege, section 25. Parental and filial privilege. No person shall be compelled to testify against or hear parents, other direct ascendant, children, or other direct descendants except when such testimony is indispensable in a crime against that person or by parent against the other. Section 26. Privilege relating to trade secrets. A person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. When disclosure is directed, the court shall take such protective measure as the interest of the owner of the trade secret and of the parties and the furtherance of justice may require. Number 3, admission and confession. Section 27, admission of a party. The act, declaration, or admission of a party as to relevant to fact may be given evidence against him or her. Section 28, offer compromise not admissible. In civil cases, an offer of compromise is not an admission of any liability and is not admissible in evidence against the offerer. Neither is evidence of conduct nor statements made in compromise negotiations admissible except when evidence otherwise discoverable to offered for another purpose, such as proving bias and prejudice of a witness. Negativing an content, undue delay, or proving an effect to obstruct a criminal investigation or prosecution. Section 29. Admission by third party. The rights of a party cannot be prejudiced by an act, declaration, or omission of another except provided. Section 30. Admission by co-partner or agent. The act of declaration or a partner or agent authorized by the party to make statement concerning the subject or which scope of his authority and during existence of a partnership or agency may be given in evidence against such party after partnership or agency shown by evidence other than the act of declaration. Section 31. Admission by conspirator. The act of declaration of a conspirator in furtherance of conspiracy and during existence may be given evidence against the co-conspirator after the conspiracy is shown by evidence other than such of declaration. Section 32 is admission by previous. Where one derives title to the property from another, the latter's act, declaration, or omission in relation to the property is evidence against the former if done while the latter holding the title. Section 33. Admission by silence. An act or declaration made the presence within the hearing or observation of a party who does or says nothing when the act declaration is such as naturally to call for action or comment if not true, and when the proper and possible for him her to do so may be given in evidence against him or her. Section 34. Confession. The declaration of an accused acknowledging his or her guilt of the offense charged or of any offense necessarily including therein may be given evidence against him or her. Last is Section 35. Similar acts as evidence.
Evidence that one did or did not do a certain thing at one time is not admissible to prove that he or she did or did not do the same or similar thing another time, but may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom or custom or usage, and the like. So that's all, sir. Thank you.